school teacher on the payroll of national government in 2013. And currently, the payroll of county governments, there are over 50,000 pre-primary teachers. And the same can be said of all sectors that are devolved. We also celebrate the fulfillment of the not more than 2/3 gender rule in all our county assemblies, unlike in the national parliament, and in our county executive committees. Your Excellencies, ladies and gentlemen, devolution has done its bit and continues to do its bit in bridging the tale of two Kenyas. As we celebrate Katiba Day today, this commemoration comes at a time when the nation is openly discussing the very challenges that led to the Constitution. Therefore, these demands that have been made are not new. They are the very promises of our Constitution. In fact, the socio-economic and environmental challenges that we have, in our view, at the Council, would have been worse without devolution. They would have been worse without Constitution 2010. We therefore must jealously guard this Constitution, including devolution and devolved governments. As county governments, we continue to aspire and to promise the nation that we will do our best to attain the highest standards of effectiveness. Your Excellency, in a summarized way, from the perspective of the county governments, through the COG, yes, devolution has done a lot. Yes, it has challenges. It's confronted by a number of challenges, including but not limited to administrative clawbacks, lack of uniformity in the application of the law, should I call it prejudice, by some oversight organs and some independent offices, inadequate resources, and delay in financing. We also have issues of the existence of subsidiary legislation and policies that predate the Constitution, not to mention the supremacy battles between the organs created by this very Constitution. In order to strengthen devolved governments, the following bold and strategic actions must be taken. Fast track the transfer of all functions and the attendant resources pursuant to the completion of the unbundling of functions. Urgently undertake policy and legal reforms to align them with the Constitution, considering that devolution is now a reality. Increase the equitable share to the county governments to enable them perform their functions optimally and ensure timely disbursements. Strengthen intergovernmental relations, galvanize the support of development partners and the private sector and the civil society so that we share the promise of devolution is as captured in our Constitution. Your Excellency, part of what we suffer here is also a bit of stereotype. As devolved units, my sister, the AG, that I really respect, referred to audit queries that say there's a lot of waste in counties. I haven't seen any audit queries that say there's more waste in counties than in the national government. I think that's part of the stereotype that we deal with as counties. I think I would really want to see that report and share it with the governors. As I conclude, I leave you on this reflective note that we should ask ourselves today, are we living to the ideals of our Constitution? when we meet here again, inshallah, in 15 years, will we still be confronted by the headlines of today? From today, let's all of us, because it's leaders of this country that are seated in here, and we're all leaders. We've been told it's not only the president that we should be pointing fingers at. We're all leaders in our own right. Let's all become champions of our constitution, from our homes to our churches, to our mosques, to our temples and shrines, and to our offices. And let's all recognize that devolution is indeed one of our national values. I thank you all, and God bless you.
We turn to the branch that gives our covenant its daily meaning through fair, impartial, and timely justice. The judiciary is the sentinel of the rule of law, protecting rights, resolving disputes, and ensuring that public power remains bounded by the Constitution and accountable to the people. Since 2010, an approximated total of 5,533 constitutional petitions and 3,595 judicial review applications have been filed against various government agencies. As Lord Denning once reminded us, a constitution is not to be interpreted like a last will and a testament, but as a living framework of government. In speaking to our reality, the Constitution must be applied with fidelity, but also with pragmatic adaptation to new social and political dynamics. As the Attorney General, I affirm the executive's respect for judicial independence and our shared duty to make justice accessible, efficient, and trusted. When courts are strong, rights are real. When jurisprudence is principled, our institutions are steadied. And when remedies are effective, the promise of the Constitution becomes the practice of governance. It is now my honor to invite my lady, Justice Martha Koome, EGH, Chief Justice and the President of the Supreme Court of Kenya, to deliver her remarks.
Thank you very much, the Honorable Attorney General, who is also the titular head of the bar. Your Excellency, the President of the Republic of Kenya, and Dr. William Samoei Ruto, allow me, for the interest of time, to abide by all the protocols that are being established and say that I recognize all the distinguished participants here this evening. It is an honor, a very great honor for me to join you all today for this historic Katiba Day commemoration, a day that reminds us of our collective resolve as a nation to live under the transformative vision of the 2010 Constitution. I also, Your Excellency, join the other speakers to thank you most sincerely for declaring that going forward, 27th August will be commemorated as Katiba Day, and also for convening this important summit and for bringing together the leadership of all arms of government, county governments, constitutional commissions, and independent offices to reflect together on the promises, responsibilities, and the enduring vision of our Constitution. The very fact that we are gathered here across institutions, across political and governance mandate is itself testament to the spirit of our constitutional democracy. This gathering demonstrates that while we may have different roles, different perspectives and mandates, we are all united in our fidelity to one supreme law, to one people, the sovereign citizens of Kenya. Our Constitution establishes constitutional democracy, a system in which the will of the people is exercised within the bounds of the Constitution. And I wish to clarify that judiciary does not exercise overreach. When we interpret the Constitution, we are merely breathing life and spirit to the Constitution. And should there be overreach, it is quickly checked on appeal, and the issues are brought within the four contours of the Constitution. Unlike other forms of government, a constitutional democracy system is not merely a majority rule, but it is about a majority rule that is restrained and guided by the rule of law. It is about the protection of the fundamental rights and recognition of dignity of every individual. The Constitution is therefore both a shield and a compass, as it protects the weak, the vulnerable, and marginalized, while guiding our nation's leadership towards justice, equality, and inclusion. The constitutional promise of national cohesion and prosperity cannot be secured by political or economic power alone. They flow from fidelity to the Constitution, respect for diversity, and inclusion in governance. Our Constitution envisages a Kenya where all communities, regardless of their size, and all citizens, regardless of their station in life, would have an equal claim to dignity, opportunity, and justice. Going forward, I hope this discussion we are having today can take part in all our counties, in all our constituency, in all our wards, in all our families, so that Kenyans can embrace constitutionalism, they can internalize the Constitution, they can own and they can claim the rights that are enshrined in the Constitution. Because when we uphold the Constitution, we nurture cohesion, and in turn, cohesion turns and becomes the fertile soil upon which peace and prosperity of our nation will grow. It is important to use this Katiba Day commemoration to reaffirm the fact that the heart and soul of our constitutional democracy are strong, independent, and accountable institutions. These institutions are designed not to operate in isolation, not to serve themselves, but to serve fleeting interests, but not also to serve fleeting interests, but to serve the people of Kenya. Every decision we make, be it in the judiciary, in the executive, or in the legislature, the question we must ask is how it impacts on Kenyans and how it promotes the spirit of the Constitution. The judiciary, in particular, occupies a unique place in this framework. It is the guardian of the Constitution, the arbiter of disputes, and the protector of our rights. The judiciary that is weak, a judiciary that is captured, a judiciary that is beholden to any authority cannot fulfill this mandate. One article of the Constitution that I celebrate every day is Article 160 that proclaims this independence and directs that judiciary or judicial decisions cannot be influenced by anybody or any authority. Therefore, an independent and well-resourced judiciary is not a privilege of judges. It is a right of every Kenyan and a safeguard for our democracy. Judicial accountability has been critical to consolidating public trust because independence goes hand in hand with accountability. And to enhance public trust and confidence in the judiciary, we, in January, established the court integrity committees in every court stations, bringing together stakeholders to identify and address corruption and unethical conduct. At a sectoral level, the judiciary, working with other agencies in the justice sector through the National Council on the Administration of Justice, spearheaded the anti-corruption strategic guiding framework for the justice sector, which was launched, Your Excellency, in March 2025, and it promotes a coordinated action in tackling corruption across institutions in the justice sector. On the other hand, the Judicial Service Commission has, since the promulgation of the Constitution, diligently carried out their constitutional mandate of ensuring accountability within the judiciary by receiving and investigating complaints against judges and judicial officers. To date, the Commission has processed a total of 946 petitions against judges, reflecting the seriousness with which it treats public grievances and the commitment to upholding integrity in the administration of justice. 4 judges have been removed from office over this period. At present, only 95 complaints remain pending, most of which are at various stages of inquiry, demonstrating both the efficiency and transparency of the Commission's processes. In addition, 210 judicial staff have been dismissed from service after due process as established misconduct on their part, which is also a clear signal that ethical lapses within the institution will not be tolerated. These figures illustrate not only the robustness of internal accountability mechanisms, but also determination of the Judicial Service Commission to maintain the highest standards of professionalism and public trust. Your Excellency, distinguished participants, democracy thrives when institutions play their constitutional roles faithfully. The executive and legislature embody the majoritarian principle, reflecting the will of the majority. The judiciary embodies the counter-majoritarian principle, ensuring that constitutional limits are respected and that rights of every individual, including the rights of the minority, are protected. I must emphasize this balance is delicate but essential for accountability and proper governance. If the judiciary were to come under the control of any authority, or if its independence is compromised, the safeguard against abuse of power would collapse. That is why the judiciary's independence is not negotiable. It is the very backbone of our constitutional democracy. The drafters of our constitution envisaged a government of separate but independent institutions. The executive, the legislature, judiciary, county government, independent offices, and commissions are all designed to check and counterbalance each other while working in harmony for the common good of our people. Mutual respect and constructive cooperation among institutions is absolutely critical. It is a constitutional requirement. When an institution remains faithful to its execution of the responsibilities and accords respect to other institutions, our democracy is strengthened, not weakened. Since the promulgation of the 2010 Constitution, the judiciary has undergone profound transformation through reforms in access to justice, the establishment of specialized courts, adoption of technology, and development of robust jurisprudence, the judiciary has sought to live up to its constitutional calling. The jurisprudence of our superior courts has clarified the scope of constitutional rights, reinforced the independence of institutions, protected devolution, strengthened electoral justice, and affirmed the supremacy of the Constitution over all persons and authorities. Currently, under the judiciary's blueprint, social transformation through access to justice, we are keen to ensure that justice is accessible to all Kenyans across the country. Indeed, these strides have not been without challenges, but they reflect the judiciary's striving to embody the spirit of Katiba. In conclusion, as we commemorate Katiba Day, let us remember that the Constitution is not self-executing, it is a promise, and this promise needs to be nurtured. It is a promise that can only be realized when leaders and institutions alike embrace it as our collective covenant. Today, as we stand together, we affirm before the people of Kenya that we remain bound together by our Constitution. Let this unity not be symbolic gathering, but a commitment to constitutionalism, justice, accountability, and service to our people. Your Excellency, distinguished leaders, may this Katiba Day inspire us to recommit ourselves to the transformative vision of the Constitution and to work faithfully with our people on the journey towards justice, peace, and prosperity. Asanteni sana. May God bless you. May God bless Kenya.
I join my lady in realizing that there are important lessons to draw from judicial reflection. Chief Justice Beverly McLachlan from Canada once stated that a constitution is not simply a legal document, it is a living tree which, by its very nature, must grow and adapt within its natural limits. Kenya too must allow its constitution to live and breathe, adapting to the realities of today's youth, technology, and global challenges, while holding fast to its foundational principles. We now turn to the arm that translates our national aspirations into binding law, allocates resources, and holds the executive to account on behalf of the sovereign people. Parliament embodies representation, legislation, and oversight grounded in our national values and enriched by public participation so that the promise of the Constitution becomes the practice of everyday governance. And I wish to confirm that the public participation bill is before Parliament, and the Leader of Majority promises that soon we'll have a legislation on that. As Attorney General, I affirm the Executive's commitment to constructive interbranch committee, candid scrutiny without recourse, cooperation without capture, and respect for the distinct mandates that make our republic stable and responsive. A principled legislature strengthens policy, safeguards public finance, and sustains public trust. It is now my honor to invite the Right Honorable Dr. Moses Masika Wetangula, EGH, Speaker of the National Assembly, to deliver his remarks.
Thank you very much, Attorney General. Your Excellency, our President, our Deputy President, and allow me to ride on the established protocols. Congratulations to Your Excellency for setting aside this Katiba Day for our nation. It reminds us in case we forget, that this was a long, winding journey to get to this constitution. Today marks 15 years since the promulgation of the Constitution of Kenya. Katiba Day is therefore a day to reflect on the 15-year journey of the implementation of the Constitution by celebrating the milestones we have made so far. It is noteworthy that the Constitution of Kenya 2010 marked a paradigm shift from the governance structure under the repealed Constitution by, among others, recognizing the centrality of the people in the conduct of the affairs of our nation. As Parliament, we are conferred with the sacrosanct constitutional functions of legislation, representation, and oversight. Over the last 15 years, Parliament has been at the forefront of ensuring the implementation of the Constitution. Your Excellency, ladies and gentlemen, looking at the 15-year journey, the following is a highlight of our key achievements as Parliament, more particularly the National Assembly. Parliament passed and enacted 63 bills to implement the Constitution as spelled out in the 5th schedule to the Constitution. The legislation included legislation on leadership and integrity, representation of the people, land and environment, devolved government, public finance, and the public service, among others. Parliament has also passed and enacted 471 bills that have promoted good governance and social and economic development of the country. The bills include the recently passed Anti-Money Laundering Amendment Bill 2025 and the Conflict of Interest Bill 2025, which are now acts of Parliament. Further, to implement the Bill of Rights under Chapter 4 of the Constitution, Parliament has enacted and passed several pieces of legislation to promote the fundamental human rights, including the right to the highest standard of health and the right to accessible and adequate housing, this being the Social Health Insurance Act and the Affordable Housing Act, respectively, among others. The National Assembly has, over the past 15 years, provided for the financing of the national budget through enactment of 13 appropriation acts. The new Constitution vests the budget process in the National Assembly. Your Excellency, ladies and gentlemen, the National Assembly appropriates resources that are essential for execution of constitutional and statutory mandates of various organs of government. Equally, funds have been appropriated to the NGCDF to fund various key national projects at the constituencies and to NGAV to fund affirmative action initiatives. As part of its mandate, the National Assembly has approved the ratification of 98 treaties and conventions in accordance with Article 26 of the Constitution and the Treaty Making and Ratification Act. This has ensured that the country's commitments to international obligations are informed by national interest. Your Excellency, ladies and gentlemen, under Article 10 and 118 of the Constitution, Parliament is obligated to ensure public access and participation. In this regard, post-2010 Constitution, Parliament is more open and accessible to the public. For instance, in the last 2 months, we have hosted over 500,000 school children and many other visitors who have had an opportunity to not only appreciate how Parliament works, but also freely interact with their elected representatives within the precincts of Parliament. Parliament continues to facilitate public participation and involvement of the people in its legislative and other business through robust public participation mechanisms, including the use of e-technology, social media platforms, and public hearings at the constituency and county levels. Since the promulgation of the new constitution, the National Assembly has received and considered 1,233 public petitions in furtherance of the right of every person to petition Parliament in terms of Article 119 of the Constitution. Your Excellency, ladies and gentlemen, the National Assembly has for the last 15 years vetted 199 state officers nominated for appointment to various state offices, including cabinet secretaries, principal secretaries, holders of independent offices and commissions, and diplomatic postings. The National Assembly has processed 3,427 questions and required cabinet secretaries to respond to questions in plenary on various matters of concern to the people of Kenya. In the last 15 years, the National Assembly has initiated and considered 18 impeachment motions, including impeachment motions against cabinet secretaries and holders of independent offices and constitutional commissions accused of violating the Constitution. This has ensured compliance with the guiding principles of leadership and integrity by state officers. Suffice to mention that we also considered a motion for impeachment of a deputy president. As part of oversight, the National Assembly, through its watchdog committees, continues to examine the audited accounts of state organs to ensure the prudent use of public resources by state organs. Further, the Public Debt Committee of the National Assembly oversights the National Treasury to ensure responsible borrowing and compliance with the statutory public debt ceilings, which is an issue of concern to the people of Kenya. Over the period, the National Assembly approved 4 special motions for deployment of KDF in DRC Congo, within the country, and the deployment of the National Police Service to the country of Haiti. Your Excellency, ladies and gentlemen, the National Assembly has passed and enacted several electoral laws in compliance with the general principles of the electoral system, including free and fair elections, which are simple, accurate, verifiable, secure, accountable, and transparent, as provided for under Article 81 of the Constitution. Additionally, the National Assembly has previously facilitated the selection and constitution of the IEBC, including the recent appointment of the chairperson and members of the IEBC. Your Excellency, ladies and gentlemen, Parliament has over the relevant period passed 27 division of revenue bills and count allocation of revenue bills to ensure adequate allocation of national revenue to counties. It is important to note that in the current 2025-26 budget, the equitable share of revenue to counties stands at 21% of all revenue collected by the national government. In real terms, the equitable share of revenue allocated to counties has grown from 190 billion in the financial year 2013-2014 to 415 billion in the financial year 2025-26. This is in addition to the conditional additional allocations, donor funds, and on-source revenue for our counties. The National Assembly also engineered the operationalization of the House of Senate and 47 county assemblies by extending training, capacity building, and provision of startup staff. This cooperation and collaboration remains a continuing engagement by the National Assembly and other legislative organs. Additionally, Parliament has in the past years played critical roles in promoting constructive dialogue on the issues of national importance. An example of such is the Building Bridges Initiative and the National Dialogue Committee process, commonly referred to as BBI and NADCO, respectively. Your Excellency, ladies and gentlemen, while the achievement of the 2/3 gender rule has been elusive, the country has recorded a progressive growth of elected women in various categories. From 16 elected women members of parliament in single constituencies in 2013 general elections, we now boast of 29 women members of parliament, not to mention the 7 women governors elected by the people of Kenya. We have also recorded a significant number of elected youth to the National Assembly, which stands at 46 in the current National Assembly. Similar impressive numbers have been recorded in all our 47 counties. The Constitution 2010 led to the establishment of a bicameral legislature and increased members from 224 to 418. To this end, Parliament has undergone several structural developments to cater for the increased membership, including construction of the office complex, namely the Bunge Tower, and other attendant facilities. Your Excellency, ladies and gentlemen, from the foregoing, Parliament has indeed made great strides and achieved key milestones in facilitating the realization of the aspirations of the people of Kenya under the new Constitution. Our Parliament has become an admirable and appreciable benchmarking center for many parliaments seeking to learn on best practices and ideals of parliamentary democracy born out of our 2010 Constitution. Going to the future, Your Excellency, it is necessary to enact a clear law that deals with the issue of public participation. The Attorney General, cooperating with Parliament, has a draft bill that is before the House, which is now being harmonized by the House Committee with 2 other bills that were drafted by individual members so that we can simplify and make public participation user-friendly, cost-effective to avoid unnecessary and unhelpful duplex processes. On this particular matter, I have had discussions with Her Ladyship, the Chief Justice. I can give an example. We had a bill called the Sugar Bill. It started from the National Assembly, went through public participation, using public resources. Members of the National Assembly went all around the country to get bills, to get views from members of the public who will consume the product. We finish the bill, pass it on to the Senate. They start again the same round of public participation, going to meet the same people, pick the same views, spend the same resources from the same envelope, and if we don't do that, some Kenyan goes to court and the court say there was not adequate public participation. This is the reason why it is so important that we must have this law passed as quickly as possible, and I promise Kenyans that within the first 1 month of our resume from recess on 23rd September, this bill will be ready for presentation to the President for assent. In conclusion, the Constitution being a living and dynamic document, it is our considered view that it is desirable